Public Exchange. Valuation Services. Valuations of business, tangible assets, intellectual property, intangible assets, stock and securities, ESOP and private debt instruments. Financial Advisory Services. Primarily focused on providing advisory services in the areas of corporate finance, capital structuring, transaction advisory and M&A. Credit Rating Advisory. Our team's experience can bring in immense value by getting the desired rating upgrades or saving them from downgrades by fine-tuning the strategy. TEV Study and DPR Report. Evaluating the technological feasibility and economic viability of project to finding out the degree of risk involved. Insolvency Services. Assess Training. We are a pool of senior banker, academicians and professors specialized in all kinds of soft skill training. We are specialized in solving your all types of financial needs.
Resurgent India Knowledge Series presents virtual session on ring-fencing your legacy with effective succession and estate planning. Ms. Supriya Mohan Srivastav, Resurgent India Limited. Ms. Supriya Mohan Srivastav is a proactive and dynamic professional with a strong business acumen. She holds the cross-industry work experience on all facets of financial consulting. With a diligent go-getter attitude, she has demonstrated the ability to straddle through multiple roles involved in building a consulting practice viz. Business development, strategic planning, project execution till the delivery of assignment, across a diverse portfolio of clients and industries. Mr. Shamik Khanna, Partner, Dolce Vita Trustees. Shamik Khanna is an MBA Finance from Rotman School of Management, University of Toronto, and CTEP certified. He has over 20 years of experience and is a successful private banker, business advisor and estate planning advisor. He is a financial services professional with over 20 years of experience in financial services and estate planning. He has expertise in building and mentoring distribution network and multicultural teams to achieve business objectives. Ms. Neha Pathak, Head, Trust and Estate Planning, Motilal Oswal Wealth. Neha is the Head of Trust and Estate Planning at Motilal Oswal Wealth Management and has been associated with the group for over 9 years. Ms. Pathak carries a total work experience of 17 years in the areas of trust formation and succession planning. At Motilal Oswal, she has assisted various HNIs to plan their estates. Mr. Sudhir Chandi, Director, Resurgent Valuers Private Limited. A senior investment banking professional with more than 25 years of experience in corporate valuation, corporate advisory, corporate finance, investment banking, due diligence, private equity, fundraising, government advisory, corporate restructuring, M&A advisory together with a professional degree in chartered accountancy. A high-performing individual with a proven track record of setting up of independent business verticals and driving the growth of the business. Mr. Shivam Gerar, Partner, Dolce Vita Trustee. Shivam is a dynamic and passionate professional with experience in advising on mergers and acquisitions, corporate restructuring, fund structuring, estate and succession planning, business setups and cross-border transaction. In terms of the private client practice, he regularly advises on the structuring of intergenerational wealth transfers through private trusts and wills, the acquisition and bequest of assets, and family governance structures to prominent family offices, UVs, foreign clients, and their organizations.
Good afternoon, everyone. Welcome to our webinar series hosted by Resurgent India Limited. Wealth and businesses take years, if not generations, for the families to accumulate and set up. Taking concrete steps to protect this wealth and business from changing times, evolving laws, and vagaries and conflicts of successive generations is no longer an indulgence. Rather, it is imperative. Succession planning is a necessity and not an option, and this awareness has dawned quickly. Having a succession plan or an estate plan in place is the only way to ensure an effective and smooth transition of family business and wealth. So, in today's webinar, we will be addressing the topic of succession and estate planning, which is ring fencing with effective succession and estate planning. I am Supriya and would be moderating this session for the evening. I would like to welcome all the participants and our designated speakers, hoping it would be a really knowledgeable session for not only the participants who have joined us online, but also for the others who would be viewing the webinar through the offline mode. So before we move ahead, I would like to welcome all our speakers. So let's meet our key speakers for the day. Mr. Shammi Khanna, he is a partner at Dolce Vita Trustees. Ms. Neha Pathak, she is a head, trust and estate planning, Motilal Oswal Wealth Management. Mr. Sudhir Chandi, he is a director at Resurgent Valuers Private Limited. Mr. Shivam Gera, the partner at Dolce Vita Trustees. So moving ahead, just setting the note for the context and for the evening. Benjamin Franklin once said, the only two certainties in life are death and taxes. So considering that the specter of inheritance tax or the state duty continues to loom over us, taxes on death may soon become the third. With family-run businesses continuing to be more than the norm, then exception in India, and most of them progressing fast on the path to globalization, succession planning has never been as important as it is today. The slew of regulations around the tax and other regulatory matters, in addition to the personal laws, do not help to ease matters. Succession planning is not only a means to safeguard from a potential inheritance tax, but also a method to ensure that legacies remain alive and keep up with the changing times with minimum conflict or impact on business. Succession planning is a process and not an event in India. So with these thoughts, I would like to move to Mr. Shammi Khanna for throwing light and explaining the participants and the audience more about what is the legacy planning and what is the succession planning. So Shammi ji, we would like to hear your thoughts on the same.
Thank you, Supriya, and welcome all the attendees and participants. Succession planning or legacy planning, we can view it in different ways. Primarily, it is how you are passing on your wealth. And in legacy planning, it is more than that, how you are passing on your business enterprise to the next generation. See, it is very easy if you have financial assets or real estate to pass on to the next generation. But when it involves an operating company or a business, it means it's a living animal. And you have to spend a lot of time, take a lot of care to plan it out, how the succession will happen. In an organization, it is two levels of succession. One is within the organization, within the operating company, and within the promoter family also. So we see in India that many times still within the organization, there is some succession plan is there in effect. But at the promoter family level, it is not many families have done this. And that is the reason for that can lead to downfall of the business, because business is your bread and butter. It is the source of your wealth, not the other way around. So if you have to plan it very carefully, and it has to be done over a period of time. And that is what really is legacy planning is. how the business and your wealth will look like post you. Now, different people may have different ways of doing that, and there is no perfect solution. We always say it is customized to the need of the business that you are in, the need of the family, the structure of the family, how your business is held, whether it is a partnership, private limited, public limited, and so on, how it should be structured, who will run the business. All these things have to be taken into account before you can put a successful plan. That is what we essentially mean when we talk about legacy planning. And if you see in India, there are hardly any businesses which are lasting more than 3 generations. And this is a famous saying in every language you can go. In English, it is shirt sleeve to shirt sleeve in 3 generations. In Hindi, you can say the grandfather, Dada kamata hai, Pita badhata hai, Pota gavata hai. You take it in Punjabi, it's the same thing. You take it in Assamese, it will be the same thing. It is there in every language. And the reason is that the second generation is still attuned to the ground because they have grown with the family. But by the third generation, they are born with the silver spoon. And they are not working hard. And it is important to do that. And it's not always their fault. You have to mentor them for their induction into the business, mentor them to be a board member, and that also constitutes a legacy and succession plan. That is what we say.
Right.
I can go on, but in the paucity of time, I would stop over here.
No. Definitely. Thank you, Shamidi, for your insights. So while you talked about the generations, first generation, second generation, third generation, so definitely will would be an important aspect. So coming to you, Neha, if you could throw light on, how the trust and the will play an important part in the succession planning.
So thank you, Supriya. Good evening to all the viewers. First of all, I should say there are multiple ways by which wills and trusts play an important part in the legacy or succession planning, particularly when we talk about the transfer of assets and the protection of one's interest after they have passed away. So some of the important things that one should know is that the first one would be the asset distribution. Now, as we know, will is a document that outlines how a person's assets, including property, investments, possessions, how they get distributed after the demise of an individual. By having a proper will in place, individuals can ensure that their assets are transferred according to their wishes. However, one should also know this, by forming a trust, one can provide a clear and legally binding plan for the beneficiaries, how the assets will be distributed after one is not there anymore. Now, when we talk about wills and trusts, one of the things that we always say that whenever there is a minor involved, there should be guardianship clause that should be put in. Now, when you put a guardianship clause, that is very important and critical when we make a will. But there are instances, and we have seen in the past 2-3 years, especially during COVID, the unavailability of having a guardian in place, or something happens to the guardian and people have not made those changes in the will, then it becomes a public domain. The child is left out in the open to be taken care of whoever comes his way. So trust actually forms like a very good ground or very good structure which can take care of the child, which can protect the child and hold the assets till he becomes of a proper age. One of the things that are also important are business succession. For business owners, wills and trusts are vital in succession planning. Through these documents, they can specify how the business should be transferred or managed after their passing away. This ensures a smooth transition, minimizes potential conflicts amongst the heir, and also helps maintain a continuity and stability in the business. Like how Shami said just now, that after the third generation, the business might not survive. The business might not survive, but there might be professionals who may be able to take over the business and may be able to run the business. So we can hope for that, and that is what a trust or a structure like a trust can help the family to take the business or the well-being of the family forward. Another issue that another aspect that I would look at is healthcare and financial decisions. Or whether we talk about an individual who's creating the trust or individual who's creating the will or the beneficiaries, either which ways, healthcare is a very, very important aspect. One should look at that very carefully, that in case I am the one who's creating the trust, it shouldn't be the fact that I myself get excluded from taking care of myself. So I should provide for my well-being also along with the well-being of the other family members.
Right.
Another aspect would be minimizing conflict and legal challenges. And this happens to be one of the most important aspects when we talk about business families. So when there is any document which is a legal document, it has to be a well-drafted and legally valid document. It should be made in such a manner, the terms and conditions should be so clear that it minimizes the potential disputes that might arise between the family members or within the other beneficiaries who are mentioned over there. Supriya, on to you.
Yeah, thank you, Neha, for your insights. So like as you well mentioned about the assets, the protection of the interest, as well as the asset distribution, for minimizing the conflicts. So Sudhirji would like to understand from you, is there any kind of a valuation? Because then valuation would play an important aspect when we are talking about the asset distribution, and the conflict should be minimized, some kind of a legal document which Neha talked about for the validity, for the transfer of the asset. So how do you think, is there any valuation requirement which is there for the structuring the will during estate and the succession planning? Your thoughts on the same, sir?
Yeah, thank you so much, Supriya. And good evening, all the participants. You answered your question yourself, right? As Neha said, distribution is very important, right? So suppose it's an FD, right? Or some liquid investment. Distribution is easy, right? Among your legal heirs. But if it is, say, an operating business, as Shami was saying, there are businesses which are run in the family. There could be one business, two business, or three businesses. Then how you will distribute? That is very important. And that is where the valuation comes into picture. And what happens is that typically these are all businessmen, who are very, very involved in their businesses, running their businesses. They are actually not knowing their value. They may have a thumb rule kind of a valuation that I have this much net worth or I'm doing this much revenue. So this would be my value.
Okay.
Right. But that generally doesn't happen. You need to give a very serious thought in terms of what the value is. So actually you need to appoint a valuer, who can give you a systematically approach, in terms of how to value that. And this succession planning may also involve, right? Not only, one way is that, you are distributing your business, you are giving shares to your legal heir, right? But as Shami said, third generation mein jaake, there is somebody maybe, who's not capable enough to run the business. So then what is the solution if you don't have a capable legal heir? So the best way is that you sell the business to a third party. And whatever, the proceeds are there, you distribute among your legal heir. That becomes an easier way. That way, the business also gets protected and you are able to maximize the value. But how will you sell unless you know the value? So value becomes very, very important in terms of, finding out how I have to do the succession planning. Number two, as you also said, and Shami also said, succession planning is a process, right? It's not an event. So it's not on a particular date, that today I'm thinking of succession planning and I'll do it overnight. No, it doesn't happen. So you need to give at least a 5-year, 3-year time frame. So now what happens is that if you, value your business today, then it will also, give you idea that from where the value is coming.
Right.
So you started with the succession planning, but now you are creating value. So you know the value levers now. So you will start creating value. So suppose you are 100 today. Now you have a valuation report in hand. You know where the levers are, whether I need to improve the efficiency, whether I need to improve the revenues or the margins. you know how competitors are behaving. So that way you can also create value. So I think valuation in a way, serves, number one, helps in distribution. Number two, it helps in creating value. And there could be a third aspect also, right? Because what happens is, we have to see it from the employee's perspective also. These all family-run businesses or the professional businesses where owners have some stake, right? They have very, very key employees who are part of this, organization or the group. Now, if somebody who's at the helm of the affair, leaves, then these employees may also leave. They have a loyalty kind of a thing, right? So if there is a proper valuation and they see that valuation is going to be preserved in future, they will stay and the valuation will be preserved.
Right. Thank you. Thank you, sir, so much for your insights. So Neha, coming back to you, like you explained about the role of the will in terms of legacy planning and all. So would like to understand more, like what are the essential components of a will, which should be there? Neha, you are on mute, please.
I think I was on mute. I'm so sorry.
Yeah.
So will, also known as the last will and testament, is a legal document that outlines a person's assets that should be distributed after his passing away. So some of the essential components, if one has to look at what are the key components of a will, are first of all, the person who's making the will, his information. That's also known as the testator, legally known as the testator. His information should be there while creating the will. So this information would have that, what is his full name, what is he also known as, what are the other information. Nowadays, we have information like Aadhaar card, PAN card details, or have addresses. So those are the details for the testator. That is the key important thing for the testator. Second thing which the will should carry is a statement of revocation. So the will has to state that, if I'm making the will, I would put in a sentence that I am revoking any previous will or codicil. Codicil is basically amendment to the will, to ensure that the latest will is considered as a valid and operative will. Third important aspect would be, which I have seen a lot of people missing out in their wills, is appointment of the executor. Executor is the person who is basically responsible for carrying out the instructions that are mentioned in the will. The executor's role basically is that to pay the taxes, to ensure the assets are distributed properly, to take the will to the court, get a probate on the will, and so on. So his duty starts when the person passes away and ends after the distribution of the assets which are mentioned in the will. So he's a very important person who should be mentioned in the will. There should be an alternate executor also that should be mentioned, just to ensure that if there is any contingency that occurs, that person is there. Fourth thing is, a person should mention what are the assets that he has. So assets, what a person has is, it can be a bank account. So put in the bank account number and which is the bank that is carrying your account. If you have got shares that are held in a demat account, put in the name of the demat account number and the name of the company that is holding it for you, and not the number of shares or the valuation of the shares. Similarly, it goes for property. Similarly, it goes for any other asset that you hold. Then you should mention who the beneficiaries are of your will. So who are these people who will be benefiting and how much they will be benefiting? So it can be, beneficiaries can be a family member, it can be friends, it can be charitable organizations, it can be entities, it can be anybody. So one should mention who are these beneficiaries who will be benefiting from these assets, and how this asset will be distributed amongst these beneficiaries. Again, a very important aspect, that how the distribution should be done. If there are minors involved in the family, then of course mention the guardians, who is going to be the guardian for the minor, until what age the guardianship would lie. There should be a residuary clause that should be mentioned in the will to cover any other assets that are not specifically mentioned in the will, and how these assets and to whom these assets will be distributed. And lastly, one should not forget that the will has to be signed dated, and witnessed. Witness has to be has to be done by the person making the will, who's the testator. Witnesses, there are at least 2 witnesses that are required for the will. And these witnesses are basically witnessing the person saying that we have seen the testator signing the document, which is the will, and he has the required mental capacity, and that the will was not executed under duress. So witnesses generally should be people who are younger than the person who's making the will, so that they continue while even if the testator is not there.
Right. Right. Thank you, Neha. So while we were discussing about the will and, the passing of the legacy to the legal heir. So coming to you, Shivam, I would like to understand from you, is there any kind of a difference between the legal heir certificate, the succession certificate, and the probate, what Neha was talking about?
Okay. I will explain about the legal heir certificate and the succession certificate first, and then we will come at probate. So when a person dies in estate, that is, if a person dies without making a will, then his legal heirs comes in, and there are various ownership issues which arises, since all legal heirs want some property portion from the property of the person who had died recently. So each state has the requirement of legal heir certificate and succession certificate. So legal heir certificate is applied through the court of competent jurisdiction in which the person is resident or his immovable property is situated. So it defines the relationship of the legal heirs with the person who has died. Along with that, it lists down the properties which are to be transferred to the legal heirs. Okay. On the other hand, legal heir certificate is just required for establishing the relationship of the legal heirs with the person who has died. So succession certificate is used for transferring of properties of the person who has died in estate, and legal heir certificate can be used. Legal heir certificate can be used for transferring of provident fund and movable property unless and until it is challenged. So succession certificate is critical.
Right.
Now coming to the probate process, probate is required in case of certain cases in a person who has died after making the will. So at the time of execution of the will, there are certain states which requires to give a legal sanction to the will. Just like state of West Bengal, Bombay, and Chennai. If the person who has died after making the will is resident in Mumbai, Chennai, or West Bengal, or has property there, he has to, the executor has to apply it to the court of competent jurisdiction of that state, and thereafter take a legal sanction from the court, and court publishes the documents publicly for 30 days, and whoever wants to object it, they can file objection. And once the order is given by the court, the will is granted a legal sanction. So
Okay.
probate gives a legal sanction to the will.
Okay.
That's a
Thank you, Shivam.
major difference.
Yeah. Okay. So thank you, Shivam. Like we were discussing about the legal here certificate here. So Neha, coming back to you, would like to understand more on like what are the legal grounds and the circumstances under which the legal heirs can challenge the validity of a will, and what is the process for doing so in India?
So as in India, we have, amongst the lawyers, at least we have a saying that, one can challenge anything under the sun, including God. I remember I was in the High Court and somebody challenged and tried to pass a motion which said that, declare me as God. That was one of the things that happened. So yes, will can be challenged, and there are various ways it can be challenged. Not only legal heirs, but outsiders also can challenge the will. One would be the lack of testamentary capacity, which means that this is one of the most common ground to challenge the will. It basically is that the person who's making the will lacked the testamentary capacity. So basically he was, while making the will, which means that the person who's creating the will, he may not have been of sound mind, and he would not understand the nature and consequence of making the will. And if there is evidence to suggest that the person was mentally incapable of making a rational decision, the will may be challenged on this ground.
Right.
The other thing might be that person might be under undue influence. A will may be challenged if there is an evidence to suggest that the testator was unduly influenced or coerced by somebody into making a will against their own wishes. Undue influences involve a situation where the free will of the testator is overpowered by another person's influence, and as a result, the testator's true intentions are not reflected in the will. The third would be very common factor would be fraud or forgery. So if there is evidence to suggest that there is a will is fraudulent or forged, it can be challenged on these grounds. This includes situations where signature of the testator or witness might have been forged, or there's a fraudulent misinterpretation or tampering with the contents of the will.
Right.
Another one would be a lack of proper execution. Now, this happens a lot where people make the will, never sign it, or they haven't got the witnesses to sign it. So in India, wills must comply with certain formalities as prescribed under the law, which says that a will should be properly executed as per the legal requirements, such as one should have sign the will, it should be witnessed. Sometimes it might be notarized. So if it is not done in that manner, it might be the grounds of lack of proper execution. So these will be the grounds where a person might challenge the will.
Okay. So Shamiji, coming to you, like earlier Neha has also mentioned about the trust, right, along with the will. So would like to understand from you how the private trust is different from the will, and how can the trust ring fence the assets of the families? So if you can throw some light onto the same.
Yeah, that's a very important point. See, will, why there is a difference between will and private trust? I will first put it across. Will comes into execution only once the testator is no more. So he's not there to explain what his wishes were, that he was of sound mind, or all of the grounds on which Neha mentioned, which can be challenged. In case of a private trust, the assets are transferred most of the times during the lifetime of the testator. That means if I am making a trust, I'm transferring the assets into the trust and it becomes operational during my lifetime. So the chances of it being challenged becomes very less, right?
Okay.
Second is how it can be ring fenced. So there are different types of trust, the broadly being revocable and irrevocable. Irrevocable trust is a trust which cannot be revoked at the will of the settler. In the trust, the settler is the person who settles or who is the author of the trust. Then there are trustees who are like a board who manages the assets or the companies in it. And then there are beneficiaries for the benefit of whom the trustees were.
Right.
So if that trust cannot be revoked, it is called irrevocable. And then there is a discretionary and determinate trust. A determinate trust is a one where the share of each beneficiary is defined, say 10%, 20%, 50%, or whatever ratio. On the other hand, discretionary, that trust is the portion is not defined and it is left to the wisdom of the trustees with some guidance to the trustees in this matter by the settler.
Okay.
If the trusts are a discretionary trust and irrevocable trust, that is a hybrid kind of a trust, then a ring fencing can be accorded to the assets under the trust. Because reason being that the ownership of the title of the assets have been passed on to the trust, and it is not the ownership of an individual. It is a group of individuals. Because trusts in India are also referred to as, especially the private trust, as AOPs, association of persons. So in this case, it is an association of family members or the future generations. Once it is there, if it is structured properly in a particular manner, then if the assets are there, then they can be ring-fenced from various risks. That can be marital discords, it can be legal risk, it can be creditor risk, it can be other risks also, whatever you can think of. But then it has to be structured as well as operated in a manner where it is actually discretionary, not in a fixed manner. That is important. some people make the mistake that they write something in the trust deed, but in operation, it is operated like a determinate trust. Because if it is operated like a determinate trust, tomorrow the courts can take a view that this is not a discretionary trust and the assets will not get a ring fence.
Okay. Okay.
Now, there are some public examples we can say, like Mafatlal House in Pada Road. It is in a trust. Now, we all know what has gone through the Mafatlal family. It's a public knowledge. We can discuss it. Bankruptcy, marital discords, family disputes, whatever not. But the property that was put on it has been structured in a way the trustee, all the beneficiaries have the right to live in the house, but they cannot sell it or they cannot rent it. They can only use for self-use as living by paying a nominal rent to the trust. So
Right.
this is
Right. So thank you, Shamiji. And Shivam, coming to you, like as Shamiji has highlighted that private trust is an inevitable tool for an estate planning. So could you also, elaborate about the taxation perspective of the private trust in India, the taxation regime?
Sure. So there are around four heads of taxes, income tax heads in India. First is salary, then income, capital gain, and then PGBP and house property. And the last one, fifth one, is income from other sources. Now, if the property is settled into a private trust, an irrevocable private trust, so first we have to check under which head it will be taxable. So it will not be taxable in the house property, salary, PGBP, profit gain from business and profession. And then there comes a capital gain. So section 47 comes into this picture. When a property is, or a capital asset or an asset is transferred into an irrevocable trust by way of gift, it is not considered as a transfer. So it will not be, there will be no capital gain. Now, if there is no capital gain, then income from other sources comes in. Under 56(2)(10) of the Income Tax Act, a property distributed to the trust created for the benefit of his relatives, then in such case, income tax will not be chargeable under the head of income from other sources also. So settlement in the trust is exempt, subject to the condition that the trust is settled for the relatives, which is defined under the Income Tax Act, relatives definition. Now coming to the operations of the trust. Now, when the trust is operation, the assets are settled. Now there is a taxability in the hands of trustee. Trustee is assessed as a representative assessee of the trust, and the income tax is levied on the trustee itself, and trustee pays off from the income of the trust. Now there comes two concepts for determinate trust and indeterminate trust. Determinate trusts are those trusts in which the shares of the beneficiaries are defined. And there comes an indeterminate trust, wherein which is also called a discretionary trust, in which the beneficiary shares is not defined. Now, in case of beneficiary shares are not defined, the income of the trust is charged at maximum marginal rate. Generally, it is chargeable at the rate of beneficiary at individual level. If there are certain exceptions under those cases, generally it is charged at MMR. However, in case of determinate trust, and it does not include income from business or profession, in such cases, the income tax slab applicable to the beneficiaries are taxable similarly for the trust also. So that is basically the overview of taxation.
Right. Thank you, Shivam. So, these are coming to you, sir, while we were talking about, like Shamiji said, about ring fencing of assets, the asset distribution as Neha highlighted, and now the taxation regime as has been slated by Shivam. So would like to understand from you if you can advise how the families need to adopt, like what valuation approaches, what valuation methodologies at any particular event. If you could throw some light on the same, sir.
Yeah, thank you. So the next question, first we have established that we need valuation, then the next logical question is that how to do the valuation, right? So it really depends, what is the nature of the asset, that is the starting point in understanding. So we are taking an example, right? Suppose it's a unlisted business, because if it's a listed business, maybe shares are listed, you can have market prices for that. If it's a liquid investment, mutual funds and all, there is a ready market for that. But if it's an unlisted business, the problem starts from there. And also there could be certain other assets where a ready market may not be available. So valuing anything under the sun, there are only 3 internationally accepted approaches. And these are income approach, market approach, and also asset approach. So there are various different methodologies which form part of these approaches, and those would really depend on what kind of asset it is. So if I talk about income approach is primarily what the business will earn in future, and that is going to be discounted back today to understand what is the value today. Suppose there is a business, which is going to give you, say, 10 rupees every year, right? So how much you will pay today? So it all depends, what is your expected rate of return. Suppose you are expecting a 10% return, then obviously answer would be that value is 100. So basically you need to project into the future and discount it back to today to arrive at the value. So this is primarily known as DCF. It is one of the most popular approaches to value a business. It can also value other assets also, which are income generating assets. So all income generating assets can be valued based on DCF approach. So there are certain other, approaches under methodologies under income approach. So the other approach being market approach. Market approach is nothing but, a similar asset, which is being purchased or sold in the market, So what kind of prices it is getting. So suppose there is a pharmaceutical company which we need to value, then we'll say, how the other peers are valued. Suppose there are listed peers, or suppose there is an acquisition that has happened in that space, what kind of valuation that company got. So we derive certain ratios like EV to EBITDA, price earning, revenue multiples, depending on the nature of the company or the stage that company is into. We dig out those multiples and value that business. And the last one being the asset approach. Asset approach is basically, valuing the asset side on the market value and then deducting all the liabilities, and what is left is for the stakeholders, either the bankers or the equity shareholders. We are primarily concerned with the equity shareholders. Having said that, it is also important, right, to understand that, there could be certain discounts or there could be certain premiums that maybe need to be adopted, right? The discount could be like lack of liquidity, lack of marketability, because this is not a liquid stock, right? Unlisted investments that we are talking about.
Right.
Also, there could be, some strategic buyers who could be interested. Then we need to see whether a control premium is something that may be required to be understood. Suppose there is a lot of M&A activity happening in the sector, then maybe, some control premium also needs to be attached. So we need to do some adjustments, post we arrive at some indicative value through these methods, right? So we may use one method, we may use multiple methods, we can combine them. All sorts of things are possible depending on the scenario.
Sure. Thank you, sir. So Neha, like we were talking about the private trust, could you also help us to understand what factors would be taken into consideration while we are talking about structuring a private trust?
Sure. So when we are structuring a private trust, several factors have to be taken in consideration. But to list down a few would be the first and foremost and the most important factor would be the settler's objective. So we all, by now, I think everybody knows that there are 3 parties when we create the trust. One is the settler who's creating the trust. Second is the trustee who's managing the affairs of the trust. And the third is the beneficiary who's benefiting from the trust. Now, when the settler is creating a trust, what are the objectives? So one has to understand what are the intentions or the goals or the specific purpose of the settler, why he is creating this trust. He needs to identify the beneficiaries, their needs, special conditions, instructions, if there are any kind of control that he wants to put into the trust, that has to be looked into that. The second thing would be that what is going to be the trust property? The trust property can be the assets that you are transferring into the trust, that can be movable assets or removable assets, or as we are talking about, they can be business assets. So what is going to be the valuation or tax implication on transfer of these assets, and how and when are they going to benefit the beneficiaries? Third would be the choice of trustees. So selecting the right trustee is crucial. One has to look at their competence, their integrity, their ability to carry out the wishes of the settlor. The trustee should have a good understanding of the trust administration, investment management, legal obligations. So one has to choose the right trustees. The fourth would be the beneficiary consideration, which would be identifying the intended beneficiaries of the trust, considering their relationship. So it's very important actually to think about what is the relationship between the settlor and the beneficiary. Is there a relationship between them? If there is no relationship between the settlor and the beneficiary, then what are the tax implications there?
Right.
One has to also look at what is the trust duration. So there might be specific trust that might be created. So it can be of a specific duration, or it might end at a certain point of time. So one needs to look at what will be the term of the trust. What is the distribution and discretion? So one has to decide on what is the timing and manner of distribution to the beneficiary. So if we are looking at ring fencing of the assets, so we cannot decide on the percentage in the trust. We have to make it as a discretionary trust, and the distribution would be done as per the discretion of the trustee. That has to be, that is one of the factors. Nowadays, the new parties which are there are protectors and advisors. So when we are looking at trust nowadays, vis-a-vis trust 20, 30 years back, there was no such thing as trust advisor or trust protector. So these are the parties, maybe clients may want to look at that would they want to appoint a trust protector to ensure that there is somebody who can keep a vigil on the trustees, or who can give guidance to the trustees and give that's like a via media between the trustee and the beneficiary. Or would they want to have the advisor, the person who is advising to the trustee, or to the recommending to the trustee where to make the investments, when to make the investments, or when to make the distribution. So these kind of recommendations can be made by the advisor. When one is creating the trust, at that point of time, one should actually have consult with the tax professional for the tax considerations, to understand the tax implications on the trust structure. Understand, like how Shivam just talked about, one should understand the capital gains, the income tax, the estate laws, to ensure that to optimize the tax efficiency of the trust. Legal and regulatory requirements, similar to tax, one has to look at the legal and regulatory requirements also to ensure that the compliance with applicable laws are met with. So if you have got an NRI or a person who is not of Indian origin, so if there is a US citizen or a foreigner who is a beneficiary of the trust, then in that case, how the compliance would be taken care of. And lastly, one of the most important thing, I think, the flexibility and future amendment clause in the trust deed. So when you are creating the trust, one should ensure that there might, one has to anticipate that the only thing, according to me, this is, I think this is the best quote that I've read, the only thing which is constant is change. So one has to anticipate the potential changes that may come, and therefore provide flexibility for trust modifications. Consider including provisions for amendments, additions, revocations, or any kind of changes that a person may want in the future.
Okay, thank you, Neha. So while we are deliberating on the topic for the succession planning, family offices become an important topic to discuss about. Coming to you, Shamiji, if you could, throw some light about family offices concept in India, how they are structured, and what are the various, the bylaws for the decision making concerning the ownership, the management of the business.
Yeah. So family office is a widely, what I would say is quoted but misused term. Today, everybody says we are forming a family office. If I go back to the typical sense of family office, it's a structure in itself, which encompasses every aspect of life, that is of business family or a normal family. That will include taxation, it will include concierge, it will include wealth management, succession, it can be other aspects also thrown into it. But in India, typically, it is broadly structured either as a SFO, that is single family office, or a multi-family office. Now, single family office becomes useful for very large business families where the assets under management is very large. There is no ballpark figure because the cost of operating it is very high, because you need to have a CEO of a person, kind of a person who is managing the family office. You can have a legal experts in it. You can have company secretaries, chartered accountants, wealth management professionals, so on and so forth. Full-fledged family office. But very few families in India have that kind of a resources or the wealth to actually form a family of single family office. So most of them form is what we commonly call is multi-family office. That means some of the services are insourced and some of the services are outsourced. Now, depending on the family structure, the wealth, they can do the mix and match. And most of the wealth management offices, outfits, they offer the family office service. When they say family office service, they essentially provide two kind of services within that is wealth management or M&A kind of activity, nothing beyond that. That is what most of the wealth management outfits provide. And that is also primarily because of the regulatory reasons. Not only that they don't want to provide. If you see, most of the banks, they don't offer trust services because it is highly regulated. They consider it to be risky. So it is easier to be an independent director, if I may add, than being a trustee, because that adds more responsibility. Now, coming back to the family office, there are different other aspects in succession and this that one needs to consider. That includes family charters, that includes family business protocols, shareholder agreements, holding company structure, onshore and offshore structures. It's a combination. What is more suitable for a family is required. It is all customized solutions. There is no standard templates. Yes, templates are what are the things that one can put in. But ultimately, it has to be customized based on the family need, family structure, asset holding pattern, business needs, and so on and so forth. Family offices today are providing a very good way of pulling in the capital of the entire all family members into one place and effectively channelizing either into the business, into startups, or traditional ways of investing. And this also gives a heft to the family, because if there are 4 family members, each one is investing independently, it does not give that economies of scale. Plus, it is all scattered. There is no, vision in it. In a family office structure, you can provide a vision in terms of investment. You can provide a discipline. You can provide a discipline in terms of reporting, in terms of how the risk is measured, how you are taking the risk, and so on and so forth.
Right. So let us take some questions, because I think time is of essence and we have just next 6 minutes. So let us take some questions from the audience. Mr. Kamal Kumar Bajoria, he's talking about what about a change in will at dying declaration? So if any of your the gentlemen, Neha, if you would like to, look at that. You're on mute, Neha.
So yes, the will can be changed during the as a dying declaration. Yes, it can be done, but it is it's something that has got a lot of ifs and buts involved. Whether the person who's dying, is he lacking the mental capacity? Is he under influence of something? Is he getting just emotional? So yes, it can be changed, but it's the evidence should support that. So it's an answer. It's not an answer of a yes and no. Yes, it can be done. Of course, it can be done, but whether it can be implemented or no is something that only the courts can decide.
Okay. Mr. Sandeep Khandelwal is asking, what are the implications if will is not registered, or say whether registration of will is mandatory?
So under the Registration Act, it's not compulsory compulsory to register the will. It's not mentioned anywhere. Mostly the registration of a will is done for one's own satisfaction. There is no other reason to register a will. However, it is good to register it. It makes you feel confident that my will is fine. It's registered. One is that. Second is a lot of places, they accept it easily. Ki register kiya hai, so we can accept it. So that makes it very easy for the acceptance purpose.
So even he is asking about how the private trust and the beneficiaries are taxed in respect of the income of private trust. Would it be taxed in the hands of the trust or the beneficiaries? And also, which one is more beneficial from the taxation point of view, a discretionary trust or a determinate trust?
So it depends which trust structure is beneficial for a particular family. So suppose if you have a small asset structure and want to structure the trust for few beneficiaries among family members, 3-4 family members, then a determinate trust would be better in such case, since the income would be taxable directly in the hands of beneficiary in such case. However, in the discretionary trust, the tax is charged at maximum marginal rate. However, there are certain exceptions also. So in a small family, so if there is only one trust, there is an exception that if you have created only one trust for such beneficiary, then the income will be chargeable at the slab rate applicable to that beneficiary. So they can make discretionary trust also. So it depends if there are various multiple trust structures. In such cases, we generally advise to make discretionary trust, and a determinate trust should also be like there's a particular requirement to the particular family member that if you want to identify the beneficiary share in the trust, then the determinate trust would be beneficial.
Okay.
See, I would like to answer it slightly differently. See, that taxation, I don't know why we in India are more glued on what the tax rate is. The families who are creating the succession plan for that level, there is not huge difference in the taxation aspect. What is more important is what is important for the family, whether determining the exact share, ring fencing of the assets, or it is more about, safeguarding it for the future. That is more, should be given more importance rather than talking about the taxation, because it will not make huge difference. And in most of the trust, what we have seen is if there are immovable properties, any which way it is not taxed. It is taxed only at the time of distribution. Only the income is taxed. Even if you have an operating company, only if the dividend is coming, then only it will be taxed.
Okay.
And it will not make a huge difference if it is whether it is a determinate or a discretionary. Because how much will you get a incentive away from the maximum marginal rate? Not much.
Right. Thank you. Thank you, Shamiji. So let's take one last question. In case there is Ms. Shalakha Jivekar, in case an individual has assets abroad, does this person need to have separate wills made and registered in each country where he has assets? Or is one will registered in India enough?
See, it is always advisable that you have two trust structures, not in every country. One is an offshore trust structure and one is onshore, if you are holding the assets overseas. The reason being primarily being FEMA issues. There are issues in terms of an Indian trust holding foreign assets and vice versa. And they are more from FEMA implications rather than being a taxation issue. Plus, if the family members are, some of the family members are living abroad, right? Or they are NRIs or OCI family members, then it is better that if you have a two-tier structure, it will help them in terms of discretion in taking out the income or the corpus if required, especially in case of if you have substantial assets, because there is limitation how much you can remit each year.
Right. Right. So thank you, Shamiji, for your insights. And I think we are running short on time. We have already clocked and reached it. So let us conclude it here. It has been, this webinar has been an attempt to delve into the various aspects of succession planning, right from the wills, trust, Indian tax laws, some regulations. So it's a very dynamic and very elaborate topic, and we can keep on discussing the same at length. Right. So let us, put the curtains down here, and we hope that everybody have enjoyed it. And we are very much delighted to have such, knowledgeable speakers on board today with us, and would like to thank all the speakers on behalf of Resurgent, for being a part of us and passing on the information to all our attendees. So thank you everyone for
Thank you.
being there for us on this topic.
Thank you,
Thank you.
Supriya. Thanks,
Thank you,
everyone.
Supriya.
All the knowledge.
Thank you,
everyone.
Sudhir.
Bye.
Thanks.
Bye.
Thank you.